I do want to turn over to you, Larry. You've got a wealth of knowledge. You went to NYU Law, your Order of the Coif, magna cum laude, I believe. A lot of great credentials. You've got a great law school prep course and a lot of information to share. So I want to turn it over to you and just ask a couple of general questions. First off, when should folks start prepping for law school, and what are some common mistakes they make in the first semester or lead up to that?
Sure. I mean, those are the two most important questions, actually. I think there's that old, I think, Chinese saying, the best time to have started was 20 years ago. The next best time is today. I think a lot of people, if you go to like top law schools or Reddit, you'll see people asking the question, should I prepare for law school over the summer? Should I start preparing before? A lot of the answers put up by current or recent law school graduates will say, no, there's nothing that you can really do to prepare for law school, or it's a waste of time. I think that that answer is simply wrong. I think that if you prepare the right way in advance, it's immensely helpful and can give you the edge over other students in law school. The hard fact is that law school is graded on a strict curve, and that most of the benefits of law school, and I think this is even true amongst the elite law schools, but most of the benefits of going to law school go to those people who graduate in the top 10, top 5%. So to get there, you have to have some kind of edge over other students. I hate to talk in terms of this kind of competition. I went to a friendly law school, and my friends from law school are friends. I mean, I really, most of the people I keep in touch with are from there. But the hard fact is, at least on paper, you're competing with your friends and colleagues. So what is it that you can do? I think I do agree that there are things that, there may be ideas that people who don't know anything about law school, who do want to prepare in advance, kind of come to this with bad ideas that like, oh, I should buy the case books and read them in advance. I can give you a longer answer why you shouldn't do that, but you should not do that. Let me bridge the two questions. The first question was, what can you do in advance of law school or before you kind of get there? The second question is, what are the mistakes that people make first semester? And so I think I would bridge those by saying, if you prepare the right way, if you focus on the right things in the summer, that's the best possible way to prepare. But even if you don't prepare over the summer, if you focus on the right things during the semester, you can kind of avoid getting mediocre grades. So what do I mean by that? And I think this advice can sound counterintuitive, but it's super important. Most of the people who go to law school are good students, type A, otherwise they wouldn't be at a good law school. What I mean by that is that you're not the kind of rebel or entrepreneur that says, I'm not going to do what you tell me to do. Most people are in law school because they're really good at showing up in class and doing what the professor asks you to do, doing all the reading, showing up for all the lectures, and following up on that, and then kind of giving that back to the professor. If you take that approach to law school, if you do literally what you're told, that's the recipe to end up in the middle of the pack and not get top grades. Why is that? There is a fundamental disconnect between what you're asked to do, what 90% of your law school, what your first semester in law school is about, if you do what you're told, and what you're graded on. Your assignments during the year involve reading a casebook and being asked questions about the cases that you read about, actual legal disputes that are resolved by usually an appellate court. That's what you get. You don't get a textbook, you get a giant book full of cases. And if you've watched The Paper Chase, the professor spends it's still usually his time grilling students about the case. So you read a ton of these things. There's a lot of reading to keep up on. It's a full-time job just to read the cases. You show up for class. you don't want to look stupid in front of your very smart law school colleagues. And so that drives you to read and do that. The problem is your grade, 100% of your grade is dependent on the final exam. There's usually not midterms. Some more law schools are doing them, but they're not worth very much. And in the end, your grade depends on how well you do on an exam, but it's not an exam that you're used to. Most college exams, at least of the social science or arts and sciences ilk, involve kind of synthesizing and returning information to the professor that you learned during the semester. It's a test. They're usually tests of knowledge. I don't want to dismiss how hard college exams can be, but usually what the professor's testing is, did you listen to me? Did you do the reading? A law school exam is not quite like that. What you're presented with is an actual legal problem. It's something more akin to a math test where you learn about concepts and you don't get to see, you're not regurgitating knowledge. The test is whether or not you can apply the ideas that you've learned to completely new situations. And so in this case, a law school exam is about solving an actual legal problem, kind of developing claims on behalf of the parties and figuring out how things will be resolved. Those are not skills that you learn reading cases and being grilled on them. So if there's one thing that you take away from this webinar, it's that you need to practice. You need to practice the end game. I've been talking about the end game because it's it's apparently the first thing that you learn in chess is how to actually finish the game off. But now that Avengers came out, it's now more pop cultural, which is what I'm all about. But the most important thing is that you practice taking exams. That may be a hard thing to kind of swallow at the moment. How can I take an exam until I kind of have gone through the course? There are ways to do that. But if you focus relentlessly on learning how to solve legal problems, that is the kind of thing you should focus on over the summer. And if you keep your eye on that ball during the semester, even if you don't prepare over the summer, I think you'll be a lot better off than your peers. And if you want to be friendly and there are people that you care about, you would spread that news to them as well. So I think that's a really high-level way to answer your questions.
Thanks for that really detailed walkthrough, Larry. It's really helpful to have the background. And I'm constantly amazed at the similarities between LSAT prep and law school exam prep. One thing you said that really stood out to me, Larry, was the idea of it being like a math problem where you're not being tested on the readings in terms of having memorized information in order to regurgitate it. On the LSAT, it's the same thing. You're not memorizing information. Flashcards are of extremely limited usefulness. It's really much more about a way of thinking. And I've heard this before, kind of like logical reasoning on the LSAT is similar to issue spotting on law school exams. So I'm hoping that you can speak a little bit to that in terms of like the principal application sort of thing we see on logical reasoning, where it might be similar to law school cases in terms of issue spotting and general principles. And just for those who aren't aware of Larry's resources, I want to send everyone to Larry's website in order to get a better sense of what he has to offer. But anyway, Larry, if you could speak to that, it would be useful.
Yeah, sure. I mean, for me, the game section was a really, really long time ago. And sometimes I see LSAT blogs like yours and kind of look at that material, and I'm still stunned that so many of you have to actually learn that because it's immensely complicated. There's one area where I think the games sections of the LSAT is useful in law school, and it's a specific sub area of property where that tends to be super useful. I think more generally, the difference between skill and knowledge is I feel like knowledge is something that you can cram and skill is not. I mean, you're actually, to kind of talk about the biomechanics of it, developing a myelin sheath in your mind, that's the kind of pathway that insulates neurons. And it's what happens when you're learning a complicated physical skill like riding a bicycle or I don't know, I like to surf. Surfing is something that's muscle memory. And I think that a lot of the LSAT is like that. It's not kind of, you can kind of passively watch videos and understand how to execute on logical reasoning problems, but you can't really say that you know how to do it until you, you know, actually have practiced the problems and can do them. I think one other commonality is the time pressure that you're under. You have a very short amount of time to finish a law school exam. This is different from real life in that you will have time, a little more time. You're not going to ever just be forced to figure out a legal problem in 3 hours, which is typically how long an in-class exam is. So I think the importance of practicing and working through difficult problems and carefully tracing what, if you've missed points, what you've done wrong. I think that high level set of skills that you have developed in trying to get better at the LSAT will help you a lot in preparing for law school exams.
Thanks for that, Larry. That helped a lot. So if you wouldn't mind, do you think you could maybe walk us through what an example of a law school case might look like in terms of how we might extract, or like a scenario where we might be extracting different pieces of this real world case situation in terms of the issues that we need to be looking for to maybe classify something? I haven't gone to law school personally, so I can't speak to all the details, but I'm hoping that maybe you have a sense of what I'm getting at here and you can give us an example. I remember that within your prep course, you had this example with Spider-Man and Batman and made it real world and engaging. So if you could speak to that a little bit.
Sure. Let me try to take it from two different ways. I'll start by taking you from where you will be in law school, and that is you theoretically do have materials that I think if the professors took a different approach to them, what you do in class and reading cases would be more helpful in terms of prepping for the exam. But professors explicitly don't. There's honestly a lot of hiding the ball that happens. There's this general, you spend a lot of money to go to this institution. I think I'm slightly going on a tangent, but it'll kind of come back to the question that you've asked. You kind of infer from the professor wearing a bow tie and ivy hanging from the expensive walls of the law school that you go to, that there must be some method to the madness that you go through, that there must be some connection between the totally random set of cases that you're reading and what you'll be tested on. But there isn't. There's a huge disconnect. And when I talk to some law professors, some of them seem to be aware of this. Many of them are not, or are indifferent to that. So let me walk through, what does it mean to kind of read a case? You'll get a very specific set of facts. One of the most famous cases is Hawkins versus McGee. It's the very first case that the hero of the paper chase gets called on by John Houseman. I mean, he just says, I don't think this really happens that much anymore this way in law school, but recite the facts of Hawkins versus McGee. So the student has to, it's this case where a kid, it's a contracts class, and this person was supposed to get a transplant of skin. His hand was kind of burned or something like this, so he's supposed to get a transplant from his chest and I don't know what, I didn't even know this was possible 100 years ago. I think this is how old the case is. So they cut a little bit of skin from the chest and transplanted it to the hand. The contract was for 100% whole hand, and you learn that in contracts, the way that you ask for damages involves like getting the benefit of the bargain. So what the person had contracted for, I can't remember if it's Hawkins or McGee at this point, was a completely good hand. Instead, because the skin was cut from his chest, he got a completely hairy hand, which is not what he had bargained for. And the facts, it's a pretty vivid case when you think about like transplanting chest skin to your hand. And so as a good kind of college student, you would read every word of that case and try to have every bit of the facts at your fingertips. Most of that is not something that you'll use. What you need to get out of the case is the idea of the benefit of the bargain. So there was all this pain and suffering. This is the core of the case that gets forgotten. The guy went through all this kind of pain and suffering. What the court did was to say that he could not collect on that pain and suffering to the extent that he would have had a giant square of his chest skin cut off anyway. That was part of the benefit of the bargain. There's the whole hand, but also the fact that he was going to go through some baseline level of pain and suffering to actually get the whole hand. Okay, what does that have to do with anything? If you're approaching this from the wrong way and that you're not looking towards the end game, you think that all that matters are the little itty bitty details, like, oh, did the doctor sign the document? Did the doctor, where was this in court? What was the procedural posture? Was it, how far up did it get? Did it get to the state Supreme Court? There are all these little details that until you understand what you're eventually going to be tested on, you'll try to embed in your head. That will fill all of your time. So what you want to get out of the cases are these really simple principles, but you can get them from kind of commercial outlines that will just say Hawkins versus McGee is about expectation damages, benefit of the bargain theory of contracts. That's what you need to get out of that case. Notice that there's nothing there that causes you to have to solve a legal problem. The work has been done for you. Both of the sides have presented arguments in the case segment that you're reading, and the case has been resolved. So what the professor's asking you about in class is, what would you have argued if you were Hawkins's lawyer? What would you have argued? What else might you have argued if you were McGee's lawyer? Did the court get it right? But you've already seen, as it were, all the cards being dealt. You have to develop all of that from scratch on the exam. You just get the kind of facts that someone burned his hand and had to have a skin transplant and wanted to enter a contract, period. The arguments are not developed for you, nor is the likely outcome of that case if it gets to court. So, the kind of online course that I have develops a lot of kind of bizarre scenarios, and I try to mix different pop culture characters. I have one that involves Thelma and Louise, which is kind of an older movie, and Gregor Clegane, the mountain from Game of Thrones, being like Thelma's abusive husband. And so I try to make it relatable, because a lot of the times on the exam, the facts are very dry. If it's a little bit alive, it's a little easier. Like, you can see that person in your mind, and then you can begin to develop. If you feel like you understand the situation a little bit better, it's easier for you to develop arguments for Thelma, for the mountain, for Louise, because she was just in the car when it went over the cliff, and then begin to actually solve real legal problems that way. So, sorry to kind of take one step back. To me, that's what solving a legal problem is. You're told a story. In the case book, that story is already analyzed. And then you're already playing with it like as a food critic who didn't have to cook the food, and you even have the benefit of other critics, like there was a court that decided these cases. So you're like, was this critic right? Was that critic right? Would you have added more oregano to this? And it's really easy to be a critic, but that's the position that you're in 90% of the time during the semester. On the exam, you're the chef. You have to kind of from scratch develop arguments on both sides, develop ones that the professor will recognize as competent legal arguments, and then to make predictions, and it's necessarily probabilistic. You would never, only kind of bad lawyers say, oh, this is a slam dunk. Nothing is ever as good or as bad as it might seem. But you still have to offer some kind of resolution as to not only, so you've constructed pro and con on different sides of facts, and then you need to offer some kind of prediction as to who will win. And then you have to do this repeatedly on an exam and do it within 3 hours and do better than the rest of your classmates. So I think, I'm sorry, that was a very long answer to that question, but.
Well, thanks, Larry. That was interesting, though. I really liked how you made it real world relatable. I like the example of Thelma and Louise, and even the case of Hawkins versus McGee from the Paper Chase movie. I think it's important to recognize that, first off, these things have been analyzed by many other people, and so you have the benefit of their criticism. And secondly, I love the point you made as well, that it's not cut and dry. There's not obviously one side or the other that automatically wins. And that even reminds me of the LSAT writing sample, where you're given a situation of two sides equally weighted. You pick one, argue in favor of it, but you have to acknowledge that the other side also has some fair points. It's not obviously option A or obviously option B. Things are more complex than that. Thanks for tuning into the show. Please subscribe if you haven't done so already to be notified of new episodes as I release them. And feel free to reach out if you need anything at all as you move forward with your prep. I'm happy to help however I can. In the meantime, I'll wish you all the best and take care.